Gentlemen of the jury, you have heard the testimony and argument of counsel. It now becomes my duty to charge you as to the law in the case, and it is your duty to take the law as I charge it to you and apply it to the facts of this case. You are to disregard any remarks of counsel which you find to be inconsistent with the evidence in the case or the law as charged you by the court. You are the exclusive judges of the evidence and the credibility of the witnesses. The court is not permitted to comment either upon what has or has not been proven, or upon which witnesses you should believe or not believe. In judging the credibility of any witness, you should take into consideration his or her demeanor upon the witness stand, his or her capacity and opportunity for making accurate observations, and the interest that he or she may have in the outcome of the case. In criminal cases, the state must overcome the presumption of innocence and prove the accused guilty beyond a reasonable doubt. In a civil case such as this, the rule is different. The burden is upon the defendant to prove the case beyond a reasonable doubt. In this case, then, if you find that the plaintiff contributed by her actions or omissions in any way whatsoever to the occurrence alleged, then in that event she cannot recover and you must return a verdict for the defendants, because Louisiana recognizes the rule of contributory negligence. You are instructed that contributory negligence is an affirmative defense, and the defendant must prove such a defense by a preponderance of the evidence. If the evidence on each side of this issue is of equal weight, that is, if the evidence in favor of the contributory negligence of the plaintiff does not outweigh or overbalance the evidence opposed to his contributory negligence, then the burden of proof of contributory negligence has not been met by the defendant, and you must find in favor of the plaintiff on this issue. However, you may consider evidence introduced by all parties. Sir, did you have any discussion with Dr. Diamond about how your condition came to be what it was when you saw him that day? Defendant's counsel. Objection. The court. That was leading. Sustained. Defendant's counsel. It probably was. Sorry, Your Honor. The court. Just tell us the conversation. You talked to him and he talked to you. Tell the jury everything else in the conversation that was said. Judge, do you mean on the first visit? The court. Yes, on that visit. Well, he discussed the physical therapy because I wasn't supposed to be doing those straight leg raising exercises. The court. I want to be sure I understand what you said he said. Yes, it had to do with range of motion and straight leg raising. Did Dr. Diamond recommend any course of action at that time? Yes, he recommended surgery. Did he tell you what to expect in the surgery? Yes. Tell us what he said. He told me if I had an operation in the near future, without waiting, it would be better for me. Was the operation eventually performed on you? Yes. Do you remember when the operation was performed? 2 days later, on February 14th. Did you have an appointment with Dr. Diamond scheduled for after the surgery? Defendant's counsel. I object, Your Honor. Immaterial. The court. No, I will permit it. Overruled. Yes. Do you remember how long after the surgery your first visit with Dr. Diamond was scheduled? I think it was about a week. And did you attend that visit? Yes, I did. During the week following your surgery, before you saw Dr. Diamond, how did you feel? Defendant's counsel. Is all this necessary, Judge? I object to it. The court. He is filling in the background. Overruled. Plaintiff's counsel. I would be finished quicker if counsel would not keep interrupting. The court. No, he has a right to object when he sees fit. I have forgotten the question. How did you feel the next week? I had soreness in my back. I had more pain this time going down my right leg and into my foot. Did you continue to feel a tingling sensation? Yes, I still felt it. What about the numbness in the foot? Yes, in my right foot. Defendant's counsel. Your Honor, can the witness testify and not counsel? The court. Yes, try not to lead. When you went to see Dr. Diamond, did you tell him about these symptoms you were having? Yes, I did. Do you recall what, if any, response he had? He told me at that time that the second operation would have been healing that was a little bit different. Did he tell you why it would be different? Yes. What did he say? That the surgery was riskier because he was going back to a spot that he had already operated on. The court, excuse me, about how much longer will your examination be, do you think, sir? I am not trying to in any way inhibit your examination, but for the sake of planning and allowing the jury to have an appropriate respite, I would like to get an idea. Plaintiff's counsel, I would estimate another 15 or 20 minutes at least. The court, all right, finish up. Do you remember any discussion you had with Dr. Diamond at a subsequent visit? Yes. What was the substance of that conversation? He asked me how I was feeling afterward, after the second surgery, how I was doing. And what did you respond? Defendant's counsel, objection. Is all this conversation probative of anything, Judge? The court, objection overruled. Don't make what amounts to frivolous objections, please. Defendant's counsel, I take exception to Your Honor's remark before the jury. The court, next question, tell us what you said. I told him that I didn't feel as good as I felt after the first surgery, that I felt more pain now after the second operation than I did after the first. And how, if at all, did Dr. Diamond respond? I believe he told me it was because this time around he had to go into an area where he had previously operated. Did he say anything else? And that he had to go through scar tissue. Did Dr. Diamond prescribe any medication? I know I was given medication by him after the surgery. Did he prescribe, doctor, any other type of care or treatment? Yes. What did he prescribe? He gave me some exercises to do just before I went out walking. Defendant's counsel, objection as not responsive, if the court please. The court, overruled. Where were you to do these exercises? Well, I had explained to him I lived close to a park, so most of the time it was in a park, or there is a school nearby that has a track. What kind of exercises were they? They were squatting exercises. Anything else Dr. Diamond gave you at this post-operative visit that you remember? Not that I recall. Any other instructions? Defendant's counsel, objection, asked and answered. The court, sustained. After this visit, did you walk? Yes, I did. How did you feel when you walked? I felt pain. I couldn't go as far as before. Where did you feel pain? I felt stiffness in my lower back. Anything else? Yes, I felt pain radiating down my right leg. Where did you go where did you do this walking that you are telling us about? Usually in the park, near my home. Did you do any squatting exercises that you mentioned before? Yes. Did the doctor give you any reading material? Yes, he gave me a pamphlet which had recommendations. Did you read the pamphlet? Yes. Did you follow the recommendations in that pamphlet? Yes, I did. Defendant's counsel, I object on the ground it is immaterial. Where are we going with all this, Your Honor? The court, try to wind it up, counsel. Did you see Dr. Diamond again? Yes. Do you remember how long afterwards the next visit was? I don't remember. At any rate, at that visit, did you feel better, worse, or the same as compared to the visit before? I believe on that visit, I think I felt about the same. Defendant's counsel, is the witness guessing, Your Honor? That sounds awfully speculative. The court, I will let the jury evaluate the testimony. Go ahead, next question. Do you remember when you last did see Dr. Diamond? Yes. When was that? I think it was May or June of 2003. How was it? 190.
That was okay.